So those of you who haven't met me, I'm Dr. Kelly Cassidy. I'm the treasurer of the Institute of Clinical Psychologists who is hosting this event today. For those of you that aren't familiar with the ICP, we particularly are an organisation specifically for clinical psychologists in private practice. And today's webinar has really come out of you thinking about what are some of the things that private practitioners need to be thinking about beyond our clinical skills, which we're all really good at doing, but thinking about those other practicalities. And so I'm really excited to have Daniela here today to speak with us about these topics and get us thinking about what else we might be needing to do in our practice planning. So I think at this point I will hand over and introduce you first of all to Daniela Cera, a senior lawyer at ULegal. And I'm sure she has got lots and lots of information to share with you today. So I'll leave it with you, Daniela.
Thanks very much, Kelly, for that kind introduction. It's lovely to meet all of you and to see you all on the webinar. And thanks for coming along and sharing your lunch with me today. Today I'm going to be talking to you about preparing for the worst, risk management, and practice contingency planning. So most of us don't like to think about our demise, let alone make plans for it. And yet we all know that we must. So I'm really hoping that all of you today can approach the webinar with a sense of curiosity and that you leave with an appreciation of the tools that exist to help you to plan for contingencies. And so I'm just going to make a confession at the outset that I'm terrible with technology. I'm really happy to take any burning questions as they arise, but you'll also have an opportunity at the end of my presentation to ask any questions, and so you certainly won't miss out. Given the nature of what we're talking about and the fact that some of this is quite personal and confidential, I'm also open to any of the members contacting me after the webinar if they want to have a discussion or have any particular burning questions. My contact details will be on the slide at the end of the presentation, so don't feel like you have to ask the question in the context of this webinar today. You will have an opportunity to catch me in whatever fashion you prefer. Okay, so with that, we'll get started. As you'd expect, there's a disclaimer. This is information that is not tailored legal advice. It's for general guidance only, and we recommend, of course, that all of you seek your own personal legal advice in relation to the issues that we're talking about today. About me, it doesn't really look like me anymore. I think I need an updated headshot, and I think it's on the cards. But I'm very flattered that they've included this younger shot of me. So I've worked predominantly in private practice as a lawyer for more than 20 years. I spent about 8 years at Minter Ellison, where I was special counsel in their insurance and corporate risk team. And in that role, I was predominantly involved in defending claims where insurance companies were involved. We would become appointed, and at that stage, there'd usually be court proceedings on foot. And truthfully, at that juncture, primarily my role was focused on resolving claims as commercially as possible and really trying to extricate our insureds from the proceedings that they were part of. But what I always thought was interesting is that I'd always be asked to make risk management recommendations to the insureds to help them avoid the prospect of similar claims happening again. And I always felt like in that context, that recommendation always came in a little bit too late. I'm proud to say that in my current role with ULegal as senior lawyer, where I've been working for almost a decade, I'm working mostly in the commercial advisory setting and in employment law. And in this capacity, I'm fortunate enough to work very closely with medical and allied health practices to help them to manage their risk and reduce their exposure to claims into the future. And I think it just goes without saying that I find this work inherently more satisfying because I feel like I really can have an impact and help clients foresee the risk ahead and take measures now in the present moment to reduce their exposure and pain down the track. So I think this quote really rings true, especially in the context of our webinar today, that hindsight is a wonderful thing, but foresight is better, especially when it comes to saving life or some pain. So I think given that helping people is really at the heart of what you do, we really also want to avoid unnecessary pain, and the strategies that I'm going to be talking with you today about are really designed to reduce your risk and to spare you that pain into the long run. So in terms of the topics that I'm going to talk to you about today, broadly speaking, they relate to personal contingency planning, so planning for you and the future, and business planning around your practice and some steps that you can take now to prepare for that. And I also just want to introduce this idea of strategic risk management planning for your business as well, because I just think that's another tool that you have to be able to protect yourself against risk and loss into the future. These are topics that really do scare the pants off of most clinicians and keep them awake at night. And I think the key is just having the confidence to really begin to put them on your agenda and tackle them. And that way, putting one foot in front of the other, hopefully you can be in a position where you do cross this worry off your list because you know that it's been adequately managed and dealt with. So for context, I thought it would be worth exploring some of the trigger events that would leave us wishing that we really did have contingency plans in place. These events often can come up out of the blue and are unexpected. So some broad trigger events that have come to mind that are here on the slide include bankruptcy. So you might wonder why that's there and why it would be relevant to you and your capacity as clinicians. But I've had a previous matter involving a medical practice, and you wouldn't necessarily think that doctors would find themselves in a financial pickle. But in this scenario, one of the doctor practice owners became addicted to gambling and then developed a serious issue with managing money. And so it created havoc for the business and the other owners of the practice. Divorce and separation. So in this situation, parties will need to think about how they might divide their assets, and that can include their financial interests in the practice. Accident and illness. So if you suddenly fall sick and you don't have the capacity to work, you may develop an illness, and it may be of an immediate onset or a gradual onset over time. I mean, these unfortunate things do happen, even if we don't want to think about them. I implore you that we should. And of course, last but not least, death. So now on that happy note, these are events that we don't really want to spend our happy living years focusing on, but there's no time like the present just to get prepared. So today, as I mentioned, I'm really hoping that you come away with the confidence to tackle contingency planning for your practices one step at a time. It can be overwhelming, but you don't have to do it alone, and taking some preventative steps and actions now will mean that your practice will be protected, your patients will be looked after, and of course that your loved ones will be spared really the stress, the worry, the angst of trying to piece it all together and make sense of it all. And I'm sure all of you would be wanting to avoid that. So the first topic that I'm going to dive into as part of my presentation is the preparation of your will, and more broadly, the topic of wills in general. on average, we know that just over 50% of Australians over the age of 18 don't have a will. So that is the majority of Australians not having a will in place. And I always get blown away by this figure. I don't know why, but perhaps the reason is, like, most of us aren't planning to die in the short term, and that eventually we might get round to it when it becomes relevant for us. But as I'll explain, there are some really compelling reasons to get on the front foot now and have a will prepared if you don't already have one in place. So for those of you who don't have a will, I'll just outline for you what could happen if you die without a properly drafted will in place. So the legal term for dying without a will is basically dying intestate. And there's legislation which sets out how your assets will be shared and divided. And those rules are different in every state around Australia. In West Australia, the laws are quite involved and rather complex, and they're not hard and fast, and they can change depending on things like what the value of your estate is and how many family members you may have that may have an interest in the will. So in that case, the court would appoint someone to be the administrator of your estate, and that's quite a daunting process, because it may not necessarily end up being the person that you would like to choose to carry out that function if you had a will in place. It's up to those individuals to make an application to the court. And this can prove to be quite a complex and expensive process, particularly in circumstances where there's more than one person that puts their hand up and wants to apply for this role. And if there's no agreement between them about who it should be. And it can also be difficult in the event that no one puts their hand up to do this role. So when you die intestate, you really have no control over who is going to receive the assets. The laws really set out the methodology of how your assets are going to be distributed. And in that sense, I guess you're probably familiar with the term that the state decides, and that's certainly the case here if you don't have a will. So I would implore you to, as practice owners and as clinicians, it's absolutely essential that you would have a will, and that if you don't have one, that you give very serious consideration to preparing one. It's essential for anyone, as far as I'm concerned, that has assets and has children and is over the age of 18. So if you do operate as a sole trader, having a will is of crucial importance, and this is because you as an individual, you own your practice in your personal capacity. So it's very important that you have a will that's drawn up to protect your interests. If you have a will, your assets won't be subject to the laws of intestacy that I just took you through. You're able to nominate the person that's going to be responsible for administering your estate, your executor, and so you're able to nominate more than one person, or some people who might act in the alternate if your preferred executor isn't available to act. And that's quite important, because you do have the control over that from the outset. You get to choose how your assets are distributed. You can make specific gifts. For example, there may be some jewellery or some particular property that you would like to itemise and provide that it be received by certain beneficiaries. You're able to make legacies. And for those of you who have minor children, you're actually able to appoint your guardians as part of the will as well. So There are some really compelling reasons why you would want to prepare a will and get appropriate advice about how to best structure that. And I'm not speaking about the contingency plan in detail right now, but I just want to make a point that your contingency plan, ideally, that you would prepare for your practice should be stored in the same location as your will. And that's so the people who are nominated by you as executors can readily identify the steps that need to be taken in the event of your death. So lawyers usually have the ability to securely store your wills, or you can store them safely yourself. So I just wanted to make that point now while we're actually talking about the wills, that it's a good idea to actually consider keeping your estate lawyer appraised of the fact that you do have this practice contingency plan and storing it in the same storing at least a copy of it in the same location. So for now, I'd like to just explore the idea of estate planning, which kind of extends beyond the need just to prepare a simple will. So in addition to preparing a will, you might also want to consider preparing an enduring power of attorney. So that allows you to appoint someone that you trust to make decisions on your behalf when you're unable to do so. So in the event of incapacity, they can handle personal matters or financial matters or both. And importantly, it does apply there even if you become incapacitated. Your solicitors will probably also be able to assist with preparing advance care directives for you, which outline the decisions that you would like to make in relation to future medical treatment, and to ensure that those decisions are ultimately respected. And you may wish to appoint an enduring guardian. So that's someone who is legally authorised to make medical decisions in situations that you don't expect will happen, and to provide instructions about things that may not necessarily be covered in the advance care directive. Some other things you may want to contemplate doing are looking at reviewing your binding super nomination beneficiaries. So they authorise the super fund to know who your super will be paid out to in the event of your death. And sometimes that's something that we don't visit regularly. We just stay with the same fund for years and years and years. And perhaps the person that we may have nominated a decade or more ago may not be the person that you would like to receive the proceeds of your super super benefit in the event of your death. So that's absolutely worth reviewing and perhaps making inquiries about to ensure that that's all in order. And you may want to also consider just receiving advice about what personal insurance policies you might like to have in place for yourself, along the lines of life insurance, for instance, temporary and permanent disablement insurance, and possibly even income protection. So that's a flyover of that topic. And now what I'd like to do is just move on to talk on some steps you can take to protect your practice and financial interests. This is most relevant for those of you who are in business with others through an entity. I know that I understand many of you are operating as sole traders, but this may be relevant for you because at some point in the future, you may consider getting into a business partnership with others. And so I'd like to outline some further considerations for you in that light. So if you're in business using an entity where there's more than one owner, preparing an owner's agreement is really important. So broadly speaking, there are three different structures that practices most commonly use. They can use a company structure, so just a Pty Ltd company. They can use a unit trust, so that is where a unit trust exists, and then it's not uncommon for the trustee of that trust to be a company. And sometimes with this scenario, we find there's a unit holders agreement stapled to a shareholders agreement, but we can talk you through that if that's your current scenario. And the other vehicle that we find practices are commonly using is partnerships. Usually it's a bit more of an old-fashioned structure. It's not a perfect setup, but these are the three most common structures we find that practices may be using where they're not operating as sole traders. And so in those instances, it's important to have an agreement in place where there is more than one owner, so that there is an understanding about how the business will function. Really important. So I'll take you through some of the elements of those agreements now. So if you're a party to one of these types of agreements, you'll be wanting to look at the roles of each of the parties. You know, are you a director? Are you also a shareholder and unit holder, which presumably you will be? And what percentage of ownership do you actually have? The risks of disputes can be reduced by putting these agreements in place so that all parties are really, really clear on how the business will operate, you know, how decisions are going to be made. This is really important depending on the number of owners. So it's clear, for example, how many owners need to be in favour of a decision for it to be approved. Is it a majority? For example, who need to approve the decision, or is it unanimous, for instance? This overarching document sets all of that out, and it also sets out a process that the parties can follow where there's a deadlock, which can happen. These sorts of agreements would also typically cover the sale of an owner's interest in the business and exit strategies, including what can happen in the event of a sale. Owners' agreements can also cover off on each of their owners' responsibilities, what they're going to do, and importantly, how they're going to be paid. And being clear upfront about this can really prevent lots of angst in the longer term, where without having an agreement such as this, there's often no reference point for these matters, and it tends to be, in disputes, one of the biggest points of contention. And unfortunately, as part of our work, we do see disputes between owners relatively frequently. At the moment, if I can give you an example, our firm is currently acting for an owner involved in a shareholders dispute in an allied health business in the Supreme Court of Victoria. So the parties had been involved in a health business for a very, very long time, and it had undergone significant growth. And unfortunately, the parties had a big falling out. They each had different gripes about the other. They couldn't reach agreement about how one of the owners was going to exit. They didn't have a shareholders agreement in place to guide them. So the parties had been over some period of time engaging in discussions, and then all of a sudden, one of them just issued court proceedings without prior warning to the other. And the matter's been on foot for a few months now, but it's going to be up to a court to determine how the matters between them should be resolved, unless they're able to come to some sort of informal arrangement between them in the meantime before a trial is listed. And it's really difficult to predict with certainty what the outcome of the matter is going to be. I was also involved in another matter where there were two owners who were running an allied health business together, and they did have a shareholders agreement in place. Over time, one of the owners developed a mental health issues, and they really fell off the wagon in terms of complying with their professional obligations around clinical note-taking. And this matter didn't come to the attention of the other partner until it was a really big and widespread problem that had been occurring over a number of years and was really incapable of being remedied. The owners then had a gradual falling out, and unfortunately the offending owner then abruptly left the business. So the parties didn't have close regard to their shareholders' agreement as they were working through this dispute process until some time down the track. And they did end up avoiding court proceedings, but their dispute went on for some years and their business definitely suffered as a result of that. And the learning here is that even if you do have an owner's agreement, you do need to hold each other to account on your obligations and enforce them to be able to get any benefit out of it. So I'm quite passionate about helping clients to avoid the risks associated with becoming embroiled in litigation, which I know just from my clients' experiences and seeing that over time, that it just takes a massive toll. It's very stressful. It's got a huge financial impact and an emotional toll. And I really love to help people to avoid that. And owners' agreements can really help. And I think of them as a bit of a rule book about how everybody's going to play. And these agreements can also provide some dispute resolution mechanisms. If a dispute does arise, it provides the parties with a very clear path to follow, and it's normally quite a structured process. It's focused on getting the parties to interact and sometimes engage in alternative dispute resolution before they're able to access court processes. And the other point I want to make is like seeking advice at the outset whenever an issue pops up is really wise move. Many people really hesitate to speak to a lawyer when these scenarios present. And sometimes early intervention can really save a lot of angst, time and money in the long run. And so for those of you who want to take up the opportunity, at YouLegal we do offer our clients a free 15-minute phone calls where you are able to speak to one of our lawyers about your issues. And, you know, if we can help you very easily by pointing you in the right direction or raising something that perhaps you hadn't thought of or giving you some direction, we're delighted to be able to do that. And we don't want clients to hesitate in seeking out advice. And this is our way to help and give back. So I'm now going to delve into the topic of practice contingency planning. And I'm hopefully many of you have considered or do already have practice contingency plans in place, particularly those of you who are operating as sole traders. But it's important for those of you doing this in any capacity. And for those who haven't, I'm really hoping that your attendance today will give you that momentum that you need to begin turning your mind to preparing a plan. The plan's really integral to protecting the people that you care about, your loved ones, to ensure that they're financially secure, and of course your clients in the event that something unforeseen should happen to you. The detail that you include in this documentation is going to be a really important resource for whoever is tasked with the role of being your professional nominee. Ideally, this person should be a psychologist so that they understand the professional and ethical obligations and can act appropriately. And it's also recommended that you may want to choose one or two alternative professional nominees in the event that your preferred nominee is unable or unwilling to accept the appointment for whatever reason. Evidently, for some professional nominees, the task may be quite an onerous one and a big responsibility that they are taking on, depending on the scale and the size of your practice, and of course their own commitments and their existing workload. So it's critical that you do have discussions with all of your nominees regarding their intentions to explore their willingness to take on this significant responsibility and the terms on which they may be prepared to do this for you. For example, you may want to talk about payment. I'd also suggest that you may want to consider appointing your professional nominees as attorneys under your enduring power of attorney documentation that we discussed earlier, so that they can act in the event that you're incapacitated. So where you don't pass away, but you're not able to make decisions, or you fall ill suddenly. And of course, this paperwork should always be drawn up by a lawyer. So your contingency plan should be documented in as much detail as possible to provide your nominee with the most practical guidance about what to do, so that they can effectively step into your shoes. So your plan should be outlining, for instance, all of the points that I've touched on in the slide, which organisations need to be informed, the key security details that they would need to have access to, like your alarm codes, key login and password details, locations of keys, information about how they might access your appointment book, your diary, access your email, voicemail and computer, details of how clients can contact you, location of the client records and contact details, including information about your inactive files as well, and instructions for notifying clients, and processes for dealing with health information. So this needs to be considered and documented by you in detail ahead of time. So you need to actually find some time where you can really give this some thought. How would you like your clients to be notified about your circumstances if the worst should happen? And there are a number of approaches that you might want to consider here, but that would definitely be a matter that is personal for you. You know, will this notification, for example, extend to only current clients? Or do you want to reach out to those clients, for instance, who have recently concluded their treatment with you? Some other considerations are around, you know, how your clients' health information will be stored on their files and dealt with, and what steps need to be taken. I'd encourage you not to fall into the trap of setting and forgetting. I think you should regularly review your contingency plan and ensure it remains accurate and that it reflects your intentions and your legal obligations, which may change over time. And I know we're talking about the contingency plan here, but I implore you to have the same mindset about your will. It's not a document that you prepare once and then you just put away and don't revisit and think about. Circumstances change, and so it is something that should be diarised for review periodically to ensure that it is up to date. I'd suggest you provide your nominee with a copy of your practice contingency plan, and remember to provide them with any updates, things like passwords, for example, logins, computer programs, practices and policies may change over time, so it's important to keep them up to date. Practices can seek legal advice on the practice contingency plan if they're inclined to do so, or they want some support and they want to check in and make sure, does this ring true? Have I appropriately covered off on all the details? And as I suggested, bringing the existence of the plan to the attention of the lawyer drafting your will is really, really critical and important. And yes, again, the plan being stored together with your will to assist your executor is certainly my recommendation there. Just sorry, one other point. By storing the plan with your will, it allows the plan the ability to be more fluid and to change without impacting the will. So the plan is ordinarily not something that would be documented as part of the will itself. Otherwise, every time you want to change it, you'll be in a situation where you need to change your will. So having the document together with and separate from the will probably makes the most sense. So the last topic that I want to talk to you about now is relevant to the contingency theme around business risk management. So thinking about the types of risk that your business will face, it's obviously going to be informed by the nature of your practice and the nature of your goals as part of that. But to effectively manage your practice risk, you should be thinking about preparing for internal and external scenarios that may directly affect your business. So there's lots of issues that are relevant that do pose. There's many categories that undertaking a risk management review could canvas. So you'll need to think about the risks that are the most pertinent to your business and the most pressing. But these can be things like natural disasters, such as bushfires, floods, the pandemic, legal issues such as insurance issues, claims, contractual breaches, the risks posed by technology such as computer network failures, problems associated with outdated equipment, policy changes, security, so with the issues of fraud, loss of IP, terrorism, online security fraud, staffing for those of you who have employees, industrial relations issues, conflict management, and difficulty filling vacancies with your clinicians. These are just some sort of examples to give you an idea of the types of risks that can have an impact on your business. And it's a good starting point so that you can start to think about how you might plan if those risks were to arise. And it may be that you need to consider other risks that I haven't mentioned today, but risk management is important. It can help you to protect the practice and ensure its success going forward. So what I want to do is provide you with a bit of a flow chart about how you might actually go about undertaking a bit of a risk management plan for your own practice and the steps that you might go through in terms of choosing the key risks that could have that significant impact on your practice. So typically, when I facilitate this process for clients, I ask them to come up with the 10 risks that keep them awake at night. What are they most concerned about? What's bothering them the most? And what do they perceive would have the biggest impact on their practice if they were to come about? So it's risk recognition in identifying the risk and articulating what it is, and then moving on to assessing the risks. So working out what its impact could actually be, considering potentially whether the practice actually has any policies or practices or protocols in place that is attempting to mitigate the impact of that risk. There's then a risk evaluation process where you sit down and on balance work through what you consider to be the likelihood of the risk arising. And then you can sit back and take some action in coming up with some strategies to work through, is it possible to mitigate the risk altogether or reduce its likelihood of occurring, and what are the steps that you might need to take? So drafting then an action plan for yourself about what you might need to do to tackle it, to bring the risk down, the risk of the risk occurring down. And board approval may not necessarily be relevant here for all of you, but it's important then to just over time periodically review the risks that you have analysed regularly, so that you can see whether they are changing over time in priority, whether there may be there may be outside influences on those risks, like changes to laws which suddenly bring those risks to the top of mind again, and whether there's any further action that you might want to be taking to ensure that they're not going to have a significant impact on your business. I've facilitated risk reviews for a number of clients, and I like working with them to help them to craft some solutions to manage their risk and to keep it at the front of their mind so that they can implement strategies to tackle them and reduce their impact. And that really just allows you to focus on what's important, which is obviously the main business and why you're doing what you're doing, which is taking care of your clients. So to summarise, I think the takeaways from the session today would be to look to preparing your will. Having a will in place is really key to having your wishes respected and to adequately protecting your practice. Prepare an owner's agreement for those of you who are in business with more than one owner. Definitely make sure that you have that in place. Document your practice contingency plan, and then just devoting some time to actually managing the risks that are most relevant for your practice and putting some steps in place to reduce their impact and monitoring those on a regular basis. It's been my pleasure to speak with all of you today. I'm open to taking questions if there are any, and perhaps I'll just turn it over to you.
Daniela, I loved the reminder there to put it in your diary and update your contingency management plan. It's certainly something that I've not done particularly well, and have read it maybe a year or more later and gone, oh my goodness, this would be useless to anyone because the passwords won't work anymore, or those sorts of things. So that was certainly a really helpful takeaway that I'm going to make sure that I implement from my end. But yeah, really great if other people attending today have got any questions for you. By all means, unmute yourself and
Be scared. As I said, I'll just flip to this slide now. They're my contact details, and I've just popped my email address up there. So if any of you would like to reach out to me after the webinar about any issues, as I said, I'm really happy to answer any questions and or have a call with you to chat through any issues that you might have on this topic. I'd be delighted to hear from you. And we also have a Facebook group which is called You Legal for Doctors, but it's not just for doctors. It's for allied health. It's for practice owners. And what we do is we've got a fantastic community where they are able to ask us questions, and we also post information about relevant issues that are cropping up. There may be some new legislation or a case or a topic of interest, and we find that that's a really great resource, and it allows everybody to stay in touch and reach out to us in an informal way. So feel free to join our group. We'd be delighted to have you.
One of the things I would like to say as well for ICP members is that we are working with You Legal at the moment to put a template together for members so that it kind of steps you through the things that you might need to be thinking about for your practice contingency plan. And so hopefully that will be done very, very soon and be available for our members to access to help you in working through all the things you need to consider as part of a contingency. So I'm hoping that that will be a really useful resource for our members.
I'd just like to say thank you. Yes, there was some useful points there, and hopefully I'll get that together and store it alongside my will. So it's certainly thought, information to think about. Thank you.
Thanks very much, Julie. And if it's helpful, I'm happy to make these slides available to Kelly if she would like to disseminate them to you, just so that you can actually have those points to reflect and look at.
That'll be good. Thank you very much.
My
A
pleasure.
lot to think about.
It doesn't have to happen in one day. You just have to start making a plan and put one foot in front of the other, and you will get it together. It just takes that putting it on the agenda to make it happen.
So true.
Thank you.
And unfortunately, it's probably one that, doesn't make the agenda often enough, I suspect, which is another reason why we're drawing members' attention to this with the webinar. And it was one of our members that approached us and said, oh, can we have some resources on this? Because they were thinking about it. So certainly applaud everyone for coming along today who are starting to think about these issues or wondering what else they can be doing to protect their practice. They're important issues, but ones that we, certainly in the context of seeing clients, might let slip to the very bottom of the to-do list sometimes.
Just a quick question, if possible. With the difference between, I guess, a sole trader and then, as you say, a sort of more company structure or trust or partnership, is there differences within what should go in the will, or is the components in the will more just a reference to then, as we say, the document that's obviously then putting together the contingency plan and referencing that? So it's sort of, as you say, two separate documents, but the will's just verifying that that exists, and obviously the practice is an entity that is going to somewhere.
That's right. Well, I mean, with the practice, you may have other owners, and you may deal with some of these matters in the agreement that you have in place. But in the event that something should happen to you where you're the sole director and you're the sole shareholder, the executor of your will would be able to make an appointment of somebody to replace you. So the role of the executor becomes quite important. What's your current situation, if I could ask, Philippa?
So I'm, sole trader within that. So it would be that it's everything would go to the executor of the will.
Not necessarily. So the executor of your will is trusted with administering your wishes and your assets. They may not necessarily be the same person as your professional nominee. So that's why it's important for your practice contingency plan to be stored together with your will, so that the executor is aware of that and what your wishes are. Because it may be that your executor is not a psychologist and your professional nominee is, and it would make absolutely the most sense for that to remain the case and for your nominee to be able to carry out your wishes in the practice contingency plan. And the executor would obviously need to be aware of that. There may be issues, for example, around payment. How is that going to be structured that the executor would need to be aware of? So everybody needs to be on the same page. I hope that's answered your question, Philippa.
Yes, it's one that comes up in terms of obviously having an executor of a will and or a partner that's not a psychologist, versus then obviously having then a, as you say, professional nominee that would be a psychologist that obviously understands, as you say, the ethical sort of considerations, and or then potentially, as you say, could take over sort of the practice within that.
Correct.
Yep.
I could add something if that's okay.
Of course.
All right. Yep. In December, some colleagues and I had the very sad task of winding up a colleague who died unexpectedly. But to his credit, he was an ICP member, and to his credit, left an outstanding practice contingency plan. And the essence of it is that we did need, he had 5 of us, who were in his peer supervision group. And we had one person who was the executor of the practice, but it took 5 of us to get a hold of all his patients and work through the practice. So that's just another thought. You can have an executor, but we found it very nice, very supportive, because he had a big practice and a lot of people had to be phoned, including archive patients. And that was just like a really nice way to do it.
Amazing. So you may not just necessarily have one professional
That's what I'm
nominee.
saying.
You may have more than that, and they may need to work together to lighten the load.
Yeah, exactly. And it was a shock for us. It was also quite emotionally supportive that one person wasn't just left with the whole thing. And we wanted to make sure that that we had to also get back to the patients with suggestions of people who were willing to take on the cases. So there was more than one phone call involved.
Wendy Lynn, thanks so much for sharing that. That is a real life example of why it's important to
Unfortunately. Yeah.
Any other questions that people have got?
Kelly, it's Helen here.
Hi, Helen.
I don't know if this is a question. I'm in a group practice in a partnership, and I've nearly completed my professional will. My question is, I've already spoken to a clinical psychologist as one of my nominees. The other person I'm considering is also my office manager, who has so many details of my work. I can include her in my professional will. Is that correct?
in your professional, so do you mean the plan as the
In my
professional?
plan, yes, because she knows.
I think it would be a terrific idea to do a joint appointment.
Yeah.
Place.
Okay, because she knows everything in terms of my diary, my appointments, how I get, appointments made. So if I can nominate her as well as the clinical psychologist, and like the other person said, maybe even a couple of other people.
Yes,
that is a huge job.
it is a massive job.
Yeah,
and I think that's a wise idea.
Okay, thank you.
Can I just point out that terminology? So when I approached you legal about this, I'd sent an email to Sarah, the owner, and said, we want to do a thing on professional wills. And she did exactly what you did, Daniela, just then. What are you talking about? What's a professional will? But I think in our language, that makes sense to us, to have a professional will and a personal will. But it is a contingency management plan. Yes.
Now you've stumped the lawyer with the terminology. That's hilarious.
Yeah. Well, it doesn't look like there's any other questions for you, Daniela.
Sorry, I'll just quickly
Oh.
jump in with one, Kelly. Just to make sure I'm completely clear. The will obviously drawn up by legal lawyer side, practice contingency plan, as we say, professional will drawn up by us, but can be obviously ICP and or yourselves with you legal are doing a bit of a sort of plan within that anyway, but that basically needs to be referenced in the will, stored with the will, but not necessarily drawn up by legal.
The contingency plan doesn't necessarily need to be drawn up as by a lawyer, but as Kelly mentioned, we have partnered so that we are going to be preparing a document template that you can work from, which gives you a starting point. Obviously, you'll need to populate that, but it does give you somewhere to start from, so you're not having to document it from scratch. And if you do have any issues or concerns, you obviously can reach out to lawyers for legal advice at any time.
All right, well, I think at that point we might wind things up. So thank you very, very much, Daniela, for your time this afternoon. Very much appreciated. And thank you for your offer as well, of providing your contact details to everyone in case they've got follow-up questions or things they're thinking about. Yeah, very much appreciated. And everyone, yes, we will get the slides to you, and the recording will actually be made available as well within the next week, in case you do want to go back and be a bit clearer on any of the points that were covered. So thank you again, and have a lovely afternoon.
Thanks.
Thank you.
Bye.
Thank you.